Politics matter. You are for? No, sir. It cannot be entertained right now. If you have got any accommodation, if you have got any difficulty, ask any of your brother, sister, or friend that you have difficulty. No, sir. I'm sorry.
The matter was actually in the Harvard access. And the matter was fixed on 18th of June.
Ordered by me.
Partnered by
Coordinate by me. What do you want? Release.
Already the matter was fixed on 18th of June on the top of the list, but the kind of determination has to change that because
What can be done?
to hear this matter.
Hearing matter. As a consider. And over the sleep, I can. Under which heading? Under which heading? New motion. The new motion. Who is your senior? Come tomorrow. Come tomorrow. Take it for appropriate instruction. Yes, sir.
Item number 293 of the combined fees. My lord, out of the compensation amount, retention is fine. ADML are directed to pay the refund the amount within 15 days. Unless the next 15 are
Even you do not pay, what will be the consequences? They will be a certificate proceeding. So let them. They have not started. Have they filed any certificate? Have they initiated any certificate proceeding?
No, my lord. They have.
If they initiate part of certificate proceeding, then
My notice was started upon.
I understand. If they initiate part certificate proceeding, I believe in one day they will not dispose of. How is that? Yes. Mr. I don't request for upgradation.
That has been stated, and my land has been my.
Now, what is the point?
My point, my lord, they awarded money.
What do you want? Now, what do you want?
For application, and they in the immediate is not expired. The subscription allowed.
Very good. Application. What is that? The new motion.
No, my lord. In the motion state, it is not expired. Subscription allowed. But compensation was awarded. It developed the petitioner.
So again, it will appear in another heading portion.
Yes, my lord. Because my lord, there was a direction of the coordinate.
What direction has been passed by the coordinate bank to appear in the list under the heading motion? What a motion है ना? और कौन टा बुझते बच्चे ना मतलब लेकर? And what is the other matter? Mr. Rai.
Item number 50. Just mentioned if you are talking about strategy because the election is on tomorrow. So if you ask a minor,
What is your item number?
item number last item number 50 motion, my lord. Item number 50.
Item number?
Item number 50. People are
Kamjit हो गया.
That's where I can pay. I'm not upgraded. That's it.
Who is the other side? It will be taken up at 12 o'clock. Please inform, huh? Item number 50.
50.
15. It will be taken up at 12:30, sir.
I will inform you.
It's 12:30 p.m. Item number 50. Hello, Steve, sir. Give me also the other. For the list.
My lord, I would like to mention one matter, my lord.
Yes.
From Port Blair, my lord. My lord, there is an extreme urgency, my lord. I have already filed the writ petition before this before here, my lord, the urgency is that, my lord, the
Madam,
tehsildar.
wait. You are not audible. দেখো কোনো সমস্যা নেই। Yes, madam.
My lord, I'm audible, my lord. Am I audible? Hello.
You are not properly audible. You are from Andaman.
Am I audible, my lord?
Wait. My technical person is doing something. Mention at 2 p.m. Mention at 2 p.m. Mention at 2 p.m.
My lord.
2 p.m.
Oblige, my lord.
Not audible. Call the list.
Item number 1.
Compliant.
Part compliance is there, but due to not submission of the account by the school authority, when the school was closed, we have tried to stop, but it was returned. So when I gathered the information that the committee on 21st, 3 days back, the details was given.
So let there be another check.
Consistently adjust the matter because the lordship's passed an order on September 2023. Is the right hand that everything will be the legal amount will be disbursed for the 4 installment within a period of 2 years. So when the 2 years will be completed in September, the lordship's adjourn the matter and in the meantime full compliance shall be done.
Which date will be convenient?
September
In the month of September.
first week of September.
As per request made at the court. Is it new matter? New.
Similar matter, my lord, you must directed, my lord. The appeal on 30. On that day, my lord, Mr. Bose appeared, my lord. My lord, the matter has been settled up to Honorable Apex School. My lord, even then, my lord, they are
Paragraph number 13. Paragraph number 13 is the operating part.
you of the discussion. Yes, please, internal please.
Internal Asu.
Unless my lord, hard order is passed, my lord, they will not, my lord, release, my lord. Division bench, decided on chief justice. Item number 3.
What's for the state?
This is for existing ECL.
You have not served.
Yes. Sir,
No, it has been, you have intimated that it will be appear today.
No.
Which for the
It was-
ECN.
It was in the list. It was in the list, all along in the list.
That
From 18.
it was for the,
From 18th also they are not there. They are from the last time, last Friday, they are also not there. When you are not supposed to require, what is my identity? There might not there is the question of
Mr. Chatterjee, wait for some time. So RBC is not affected.
Yes, it's service.
No, no, sir.
It has been received on 16/6 by the receiver.
CLPI. Mr. Chatterjee, if you don't take it otherwise, please ask your junior clerk to affix the postal receipt over the relevant postal tag. Otherwise, it's very difficult to find out.
Yes, I know.
What type of they are the one? देखिए भाई एक बार देखिए एक बार तीन साल सर्विस नाम लिखी मैंने. Who is the answer is for ECL?
ECL. But here,
Give me a second, sir. Eastern Coalfield, no? This call number 3. Eastern Coalfield 8. Right. Three to five. Item delivered to address. Yes. Who is your advocate on record? Please ask your law clerk to affix the postal receipts on the relevant postal tag. It's very easy to. Unnecessary wastage of time.
or make a copy, to assist your lord. This is previous, when it was prepared by
General manager.
20 years back. Now it is not being prepared by.
Natural.
সবসময় এখানে একটা কপি রাখে, যে কোনো জিনিসের কপি রাখবে কোর্টকে অ্যাসিস্ট করার জন্য। এটা আমার গুরুর শিক্ষা। কত মহান ব্যক্তি ছিল। সময় নষ্ট কপি আছে, থেকে জিজ্ঞেস করি, শুধু খেয়াল করে নিয়েছে তোমাকে বলে বলে দেয় এমডি সার্ভিসের কপি। অসুবিধা কোথায়? সমস্যা কি ঘর থেকে আছে সমাধান দাঁড়াতেই পারতে না। 4 নম্বর আইটেম।
Yes, Mr. Chatterjee.
Yeah, the land has been taken in 1960. Protracted proceedings has been done. Ultimately, the Honorable Supreme Court has been used to direct the District Judge Bardhaman to find out
Adjust the microphone.
Who are the actually land users. Now, ultimately, the District Judge Bardhaman, initially notice was served on 60 persons. Then it was found out that 20 persons are in the fray. Out of
Are
that,
in the
are in the fray, they have been identified. Other are not identified, although the landowners raised the objection that although the landowners are raised the objection that we have not been served. All these things are recorded. Number where the Supreme Court said, very well, no, you have not been served, no further order is passed because 20% have been identified. Out of that 20, 19 have been given employment. One has been asked for the rehabilitation. He has not been asked for rehabilitation since 2014 till date. In the meantime, in 2021, there is a committee, there is a meeting of the Land Users Committee and with the ECL headquarter authority. Your Lordship will get it at page 348 of the volume number 3 of the writ petition.
Page number
48 of the volume 3.
বললেন ও আমাকে কিছু ফ্ল্যাগ দিন না ভাই
Flag দিন।
বললেন ও কিছু ফ্ল্যাগ দিন
দেখি flag রয়েছে সামনে।
Yes, Mr. Chatterjee.
Now, your Lordship can see, they have accepted page 348, first paragraph. There are 334 cases of land losers, out of which 232 were identified by the High Power Committee. Action of the progress was delayed in this case. They demanded for status in regard to all said mentioned files. They also deliberated Supreme Court judgment of 2011 and judgment came in 2014. The action taken in this regard may kindly be produced. The management said that we will abide by the Honorable Supreme Court judgment of 2011. Accordingly, 20 cases were settled. Landholders demanded HPC as recommended to another 212 cases, but till date no action has been taken.
Recommended means recommendation for what? Compensation or employment?
Compensation as well as the employment, both.
Achha.
The landlords allege that the number of the landlords' employment files is either missing or no action has been taken yet by LRE department. The management said that a fresh list of files as alleged above may bring to the notice of the office so that the matter can be verified logically. As desired by the competent authority, the concerned department HO and area will certify the land ROR details, and the list of the candidates under the package deal will be submitted by the committee. The representative of the landholders further demanded for meeting with higher authority and other officials. They also demanded for regular updation of the landowners' information seeker in regard to the progress of the matter, which is agreed as per prevailing law. The management said that all cases will be dealt as per the prevailing norms of the company. The management further assured the matter, if found in order, will be dealt with on priority basis. Demanded that further the land users demanded that the other two old cases such as Sanjay Kumar Shah and Akshay Kumar Ghosh of the Pandavasar area under 2:1 basis, whose relaxation was approved, have to be dealt on priority basis. This was mutually agreed by both the management and land users. When meeting ended. This meeting was taken place in 6th October 2021. Since then, entire silence. We have made several representations to the Land Users Committee and to the High Power Committee. Representations are all and it's clear. What I am praying at the present moment, in my writ petition, there are 11 persons, I believe. 9 persons. Out of 9, 8 are no employment or no rehabilitation. Nothing. I believe these eight are.
What would be, according to you, what would be the nature of rehabilitation?
They have asked for the rehabilitation of their land has been taken, the compensation of the land.
In terms of money.
Money.
In terms of money.
In terms of money. In terms of money.
Not in terms of another alternative land. No.
Either money or alternative, whatever it may be. After চাকরি যারা rehabilitation চেয়েছে, on it one rehabilitation.
Then Mr. Chatterjee, then what do you want now?
Now, at the present moment, I am praying. I am not asking for any interim order or any mandatory order on me. This is their own resolution. page 348. Although it is of 6/10/2021, let them submit a report whether these parcels are within these 232 or not. And one of the aspects is this. Here, one of my petitioners is Anirban Chakraborty. Pranay Kundu. Pranay Kundu. His petition interests were in the fray of the Supreme Court. And Supreme Court directed them 20% identified, 20% to be granted employment or
Supreme Court directed them.
Directed ECL 20% to be granted as it has been identified by the district judge. So 20% to be given employment or rehabilitation as they demanded. Out of 20, 19 have been asked for employment, 19 have been accommodated. My
So
client,
your client is one of the person out of that 20.
out of that 20, my
20 persons have been identified
identified
by the London district judge.
by district
The
judge
Honorable Supreme Court directed that those 20 persons be given employment.
in a content matter without going into the merits of the matter.
No. What the Honorable Supreme Court directed, that out of those 20 persons,
These
those
all
20 persons, those 20 persons are to be given employment.
No, 19 to be given employment, one rehabilitation.
You are
That rehabilitation is of my client's decision interest. He is the legal heir of that. So now he is the petitioner number 8.
And what about other petitioners?
Other petitioners, land users are there. They have not been identified or verified by the London district judge as submitting the report, which is under challenge with the Honorable Supreme Court in an Article 32 petition. This very recently. That judgment is also there. And there the Honorable Supreme Court has said, if your Lordship kindly come to page 383. The Article 32 petition was moved to the Honorable Supreme Court, challenging that finding of the London district judge dated 20th March 2013.
It has been withdrawn.
Withdrawn, Supreme Court has given liberty to approach both the concerned High Court.
Yes, with liberty to approach the jurisdictional High Court seeking appropriate relief.
So we are. In this matter, only thing your Lordship has not introduced with my son. He is my son, Swarnendu Chatterjee.
Oh, I
He is
see.
the Supreme Court practitioner.
I see.
Advocate on record in Supreme Court.
I see. The affidavit of Call the next matter.
চলো
Wait up.
May I please be first?
Is there any private respondent?
No. State and the Jilla Parishad. RS plot number
Give me a second, sir. Yes, Mr. Rai.
plots are involved. RS plot number 798 and 799.
798
And
and
799.
799.
According to the
RS.
yes, according to the government, these two RS plots were subsequently converted into LR plot number 3257.
3257.
57.
Amalgamated.
Amalgamated and 3257.
Yes.
My allegation was that, so but the RS plot I have annexed, my lord, page 37, my lord, kindly. This is the RS map, Moja, my lord, Moja map, your lordship got it?
Yes, sir.
Right hand at the bottom, my lord, it finds 798. If your lordship wants, I can, by pencil, I can.
No, you can.
I got that two plots at the bottom. This portion, my lord, will find. At that bottom right hand side.
796 I got.
After that, 798.
798 I got.
So just Damodar Nodi, this is the RS map.
798 একবার উকিলকে দেখিয়ে নাও তো এইটা কিনা এটা তো 796 হচ্ছে উনি একটু মার্ক করে দিক বুঝতে পারছি না এইটা কিনা এই যে পেন্সিল দিয়ে দাগ দিয়েছে এইটা কিনা একটু জেনে নিন এই যে পেন্সিল দিয়ে দাগ দিয়েছি না এইটা কিনা একবার জেনে নিন You mark it, sir. Mark it.
Yes.
I have properly marked.
Yes. 99, 98.
You mark it, sir. Mark it.
I have small. As your lordship held one, this is one plot, 799 manner. That's adjacent one.
791 and 798.
Yes, 798, 799. It looks like one, but it is 798. Be as it may, my lord, colleague.
Be there as it may. 798.
Be as it may. So it is just
798 and 799 they're then contiguous plot.
contiguous plot. And this is, my lord, can you consider the it was there up to Damodar Nodi Pojanto. My lord got it. And just after that plot, this is the Nodi. RS map.
নদীটা আবার কোথায় রে
Now an allegation was made.
দামোদর নদী পর্যন্ত.
Yes.
So this side is
Damodar.
Yes.
Now my lord, can you turn to page 38. The allegation was made that without acquiring the same, a road has been constructed by Bankura Jilla Parishad.
Yes.
Over my land without acquiring the same. Though this plot of land falls within the jurisdiction of Bardhaman, Purva Bardhaman. Be as it may, I made a representation. Now this honorable court directed to consider the representation in accordance with law. My lord knows. Can you turn to the order passed by this coordinate bench?
Page number, sir?
Yes, my lord. It starts from page 68. Several representation was made. Page 68 P10.
22/9/2022.
Yes, sir.
Let me see what order has been passed. Will you place
Your Lordship may kindly consider page
69?
68.
Yes, if it transfers that the allegation of the petition is correct, then the issue shall be referred to the district magistrate collector, Bankura, for necessary action to compensate the petitioner in terms of the West Bengal
Yes, it appears that the road has been constructed by acquiring.
could be as well. This code has not gone into the merit.
This was the direction passed.
So demarcation report has been prepared.
Now, my lord, kindly consider two things. LR map was considered for the purpose of relevant.
LR map was
Considered for the purpose of relevant of the property, which has not been finally published. Whether that can be considered for the purpose of relevant or not. Apart from that, let state government come and say these two plots are being amalgamated to 3256. This 3256.
no kindly
Yes.
show the demarcation report of the BLR.
Man, can you turn to page 80?
80.
80. Huh? That's a borrow report. একটা mapটা ছিল
80 is also a map.
Map. Yes, this is the LR map.
What is the amalgamation?
Yes. I grateful
3257.
to my learned friend.
3257.
Yes. Can you turn to the next page?
No,
Where-
where is 3257?
The middle. This big portion, 3257.
Which portion?
Page 80. That is page 81. Next page.
Oh. Page 81, yes.
And after that, several plots were being incorporated. Well, I got it. After that, Damodar.
No, where is 3257? That I better
See, it was this big plot.
Which one?
81, this portion.
Oh, 3257. This one.
Yes.
Joint inspection report.
Now, my lord, pause there for a moment. Apart from that, my lord, I draw your lordship attention. It is the case of the authority that those two RS plot was converted to 3257. The existence of RS plot was there just adjacent to the Moja map your lordship find from the Damodar. Initially, this map was on basis of which the demarcation was made, page 80. My lord did not find anything. No dark number and nothing. As soon as I raised the objection, this dark number was put in. What is the, I put this question to myself, what is the evidence given before publication of the final LR record of rights? We have requested that you should consider the map based on which RS finally published map, that is the RS map, on basis of which you should relay the property. And topography has been changed. Well, the existence of the plot at the adjacent of Damodar has been converted into the just inside the 24 kilometers inside. It is permissible. Well, I don't know how it has been done.
No. I understand your contention. According to you, you are the owners of plot number 790 and 790. That is RS plot.
RS plot.
Am I correct?
Yes, ma'am.
According to the respondent state, these plots have been converted to LR plot number 3257.
Yes, ma'am. According to them.
Your grievance before the coordinate bench was that without initiating any appropriate proceeding for acquisition, your land is being used. Coordinate bench directed the jurisdictional BLR to make a demarcation report.
Yes.
And on the basis of that demarcation report, your grievance will be considered by the
Yes.
district magistrate after giving due hearing to you. So what is your,
Now, my lord, what they have said,
what you are now challenging
the order passed by the district
demarcation report.
report and the district magistrate.
So where is the infirmity in the demarcation report?
Yes, my lord. Can you consider first thing? So, but the demarcation report, it was held that 3257 not been touched. That I am coming. My lord, can you turn to page 82?
Does it fall within the jurisdiction of the district court or it will go to the tribunal?
No, my lord. It is. I have not on that. Tribunal, my lord. If I raised any objection,
Sir, will you place the report
yes, my lord.
at the after the end of the survey?
After the end of survey, inquiry, preservation process, some significant facts comes out, which are
আমাকে একটু ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্ট আর ওই ল্যান্ড রিফর্মস এন্ড
manual
টেন্ডেন্সি ট্রাইব্যুনাল অ্যাক্ট এই দুটো বার করুন। Yes, sir.
is not a recorded riot of this plot. He has no possession.
No. Place one.
Yes, the present road is constructed over LR plot number 3256.
ক্লাসিফিকেশন আর রাস্তা
এই যে 82 I.
ক্লাসিফিকেশন
Rasta,
রাস্তা
total area 40 decibel.
and
Subira is not the recorded riot.
Subira is the
Petitioner
petitioner
before your lordship.
is not a recorded riot of this
Of this
plot.
plot, he has no possession of the said plot.
Then
Sri Subira is recorded riot in respect of LR plot number 3257, classified as Baluchar, and 45 decimal of land is being recorded against his name in Khatia number such and such, Mouja jail number 90. This plot is just beside plot number 3256.
on which the road is made. Very good.
Yes.
Then
The construction of said road being developed by purportedly by Bankura Jela Porishad, the said construction is no way hampering the extent of interest of Subiroy. According to the above mentioned representative Bankura Jela Porishad, first Johnson inspection report, the said road was constructed as road even before the construction was started. Moreover, beside plot number 3256, another plot number 3484 is shown over the LR map, classification of which Sali. Subira is not also recorded as the next to this plot, this one, Tamil Nadu. Now almost exists. The Subira claimed this version extend up to Tamil Nadu, but this name is not recorded in plot number 3256 and 3484, which comes between his recorded plot 3257 and Tamil Nadu.
Then after the inspection, it can be said that the
That
road
my
is
land was not utilized.
built on LR map plot number 3257. So you are challenging the correctness of the record of right.
I am
So
not
that
on
is
that.
Challenging the correctness of the record of right.
Record of rights I could have challenged if it is finally published.
Record of right was not previously.
Yes, not been finally published. Apart from that, let state government show that 3257 comprise the plot number, these two plots of the PTRS plot number such and such. 798 and 99. I'll be out of court. And how the plot has been, a plot consists of 54 decibel has been converted into the LR plot. It is showing that the demography of the map might be considered that way.
No, according if you are on this subject that record of right has not been published, then how this report has been prepared?
Yes, and it is not been finally published on basis of which this report was. So my prayer was that you should the finally publication of the RS record of right and the RS Moja, you should consider the same on that basis. Because I have shown to your lordship two different maps by the same authority without indicating what is the position and the topography.
No, this is Moja map. What I'm on.
Is
Why
not
is
been, and there is no final.
How do you say that the record has not been finally published? Mr. Dey can answer.
Yes.
Mr. Dey.
LR map can finally publish or not?
Whatever may be that, my lord, finally published or not, my lord. If in an order passed by the BLRO and if challenged by anybody, that he can file an appeal before the according to the provision of 54. And my lord, that point can't be my lord, your lordship can't be in 226 that can be challenged by anybody, my lord. He can move before the tribunal
And
if
that
he wants to do so, my lord.
But I am for the Jela Porishad Even after this, my lord, a second inspection report was prepared.
He
They-
challenged this,
They
my lord. That is the
participated in that inspection also, my lord.
report of the BLR.
Same thing came out. If he is agreed by any publication, non-publication, my lord, that has to be under challenge. He cannot challenge that before in this writ court. In appropriate forum, he has to go.
Now, my lord, his ownership is now challenged.
And finally,
Yes.
my lord, the challenge
He
is at
challenged
page
his
84.
ownership. So he must go there.
I'm challenging, I'm not challenging my ownership.
Yes, my
I'm,
lord, that is
But
the
he is
recording.
challenging the order
It
of
is
the
the-
district magistrate.
Yes.
But an appeal is prefer. It can be appeal will lie.
district magistrate order appeal does not lie.
না, না,
Probably.
ওটা আলাদা ওটা ওই পয়েন্টে তো ও তো সেই পয়েন্ট নিয়ে বলছে না ও তো
না বলছেন
এর
his
উপর বেস করে তো
challenge is
হ্যাঁ
এইটা না।
হোয়াট ইজ দ্য রং ইন দ্যাট
Yes.
সেটা দেখাও and if you challenge 82 you must go there.
I'm not challenging 82. Probably I'm unable to. The evidentiary
You must
value,
say what is the wrong in it.
unless until a map is finally published, that cannot be considered for the purpose of any sort of evidentiary value.
But you get it rectified.
It is not rectified. Rectification comes when it is published.
আরে বাবা, সেটা তো ওখানে যেতে হবে এখানে তো আর বলা যাবে না
Then my name is not appearing in the KB Khoti, and that I can challenge in the LRTT, or I have to file objection to the same. Yes, it may have not.
সে আলাদা তোমার তো সেটা
That is something else.
হ্যাঁ অবজেকশন ফাইল করবে এ করবে সব ওখানে যেতে হবে এখানে তো আসতে পারবে না পার্থ সব জানে জেনে এখন মামলা করেছে কি করবে
ইয়ে রেখেছি।
257, no?
Have you taken this point before the district magistrate?
Yes.
Sure.
Yes. I'll consider my objection. Page 73. I turn to page 75.
Yes.
Malad, kindly consider the RS. I have taken that point.
Hmm. 75, yes.
Page, last paragraph onwards, Malad, your lordship fine. And 76, last part one paragraph.
Mr. Rai, please come to paragraph number 70, page number 76. Internal page number 4, paragraph, third paragraph.
That from the report.
Forward LR map was considered, but till then LR map in Australia said Moja has not been finally published.
And in absence of finally publication of the map, the set cannot be considered. So if you are aggrieved with
RS
the
map.
inaction and non-action,
I am on the RS map. The RS map was finally published document. Let me consider on that basis. It is not their case. The final publication is the RS map. The RS map was to be considered for that purpose.
but as a matter of fact, when you are challenging the finding of the district magistrate, who had relied upon the demarcation report as made by the jurisdictional BLRO, you are practically challenging his report, correctness of the report.
But may I with your lordship, I am challenging the decision-making process adopted by the district magistrate. It is the duty of the district magistrate to consider.
Hmm.
The BLRO is acting on the basis of the direction passed by the Honorable Court. This is not exercising part on so far the purpose of the consideration of the report. My case is that you have taken into consideration of the map or certain things which has not been finally published. Unless it is finally published, I cannot raise any objection.
Hmm.
That is why the question goes. So what is the finally published document is there in the domain of the public is the RS Moja map. My prayer was that you should consider on the basis of the RS Moja map. Everything will be open. Why they are not doing the same, my lord? Let the government should come forward and say whether 3257 plot number consists of these two RS plot or not. And I can put this question to myself, how the topography of the entire plot has dimensions which change.
Take down.
And one thing, my lord, may I submit before your lordship, my lord?
Where is the order of the district magistrate?
Page 88.
Page
84.
87.
Operative 87.
Order number
8.
8.
Page 87, order number 8.
And may I submit one thing, my lord, your lordship will consider? It is the case of the respondent is that this plot number 798 and 99 is a part and parcel of LR plot number 3257.
Very good, sir.
But it is not there.
Very good, sir. Take down. Call the next matter.
My lord, on the last occasion, the lordship was pleased to direct me to serve a notice upon the respondent. My lord,
You have served.
I prefer apology, my lord. I couldn't serve in the meantime, my lord.
Very good.
I need
Uh,
only 2 more days, my lord. I will serve.
Very good. As per request made by the learned advocate for the writ petitioner, let the matter be listed on the 25th তারিখ, on July 3, 2025, under the heading another heading listed motion. Stop learning advocate. Those matters
Those matters.
have you indicated?
Lordship, kindly see the lordship's order.
Yes.
Item number 6.
এই তো সেই ম্যাটার গুলোই আসছে। হ্যাঁ,
Read service. Read service.
respond number 6.
Responses. All
Respond number 6.
the responses. It is
No, respond number 6 will not be altered.
not altered. On application dated 3rd September 2020.
Not only one.
কে আছে পঞ্চায়েতের?
পঞ্চায়েত সমিতি।
Service has been affected.
Yes, my lord,
এই দেখি দাও গো,
রিসিভ করেছে।
কল্যাণ বাবু।
ওটাও কি বলে পাঠিয়েছিস? রেজিস্ট্রি পোস্টে। আচ্ছা আচ্ছা। My lord, even my lord was pleased to fix this matter. That notice I have also served. They have received. রিসিভ করেছো? Attempt deliver. কোথায় লিখ? একটা পেজ। প্রধানটা পেজ। দেখতে হবে।
Item delivered to the Panchayat Pradhan.
তুমি এগুলো ধরো, এগুলো ধরো,
কি দিচ্ছেন উকিল বাবু দেখি?
এটা থাক।
My lord, this was the another letter, my lord. When my lord has fixed that matter, my lord, even that notice was served, they have received, the Pradhan has received.
Service is not complete.
No, item delivered on the Pradhan.
Item not delivered to the address.
No, my lord, there are two receipts, my lord. Kindly see. The first one,
Pradhan has received. Remove the board. What board?
my lord, page 32.
সীমানা নির্ধারিত সরকারি জমি কি প্রস্তাবিত বাস স্ট্যান্ড ও সরকারি উন্নয়নমূলক কাজের জন্য সংরক্ষিত। This board has been fixed at your land,
My
on your land.
on my cultivable land.
What is your case? Tell
My
me.
lord, the predecessors of the my lord petitioners herein, that is my lord one Abdul Rafiq, my lord got a patta land to the extent of my lord 2.51 acre. My lord, thereafter, my lord, in 1989 he died. My lord, we prayed for correction, incorporating our names. Representations were made. My lord,
Give me a second, sir. After the death of the late Abdul Rafiq,
yes,
you are in possession.
yes, possession, as well as we prayed for recording our name, my lord, in the record of rights.
Prayed for correction of the record of right. Then
My lord, kindly come to page 33. My lord, that is, my lord, on 28th April 2025, some of the persons, my lord, they entered into my land. My lord, there were crops. My lord, the crops were, my lord,
page number 33.
3.
You made a representation.
Yes, my lord, now, my lord, what has happened? The state has taken, my lord, 32 decimals of land, my lord, for the purpose of, my lord, this National Highway 32.
What is page number 33?
33
Regarding
is
illegal and unlawful disturbance, thereby trying to
Yes.
dispose us from our inherited
inherited
property by virtue of patta.
being number such and such.
Huh.
Yes. Now, my lord, on 28th April 2024, 5, my lord, the my lord officer, the my lord, Pradhan and all, my lord, they came, my lord, and forcefully taken the my lord, trying to, my lord, take the possession of the petitioner's land by affixing that, my lord, this board on my land. And prior to that, my lord, the crops, my lord, which we have planted, my lord, were, my lord, they have cut down all.
Bandyopadhyay, have you got any report?
Yes, my lord. I have come. Let us just forget it.
কি দেখি কি বলছেন রিপোর্টে? Yes, Mr. Bandyopadhyay.
বলবো না। Milord,
বলো।
my lord দেখছেন তো report? আমি আর বলতে পারছি, বলার দরকার নেই। My lord পড়ে নিলেই হয়ে যাবে।
Yes, Mr. Bandyopadhyay.
বলা এবার।
My lord got it?
Yes, sir.
Well, and my first point is, my lord, 6 writ petitioners.
Yes, sir.
6 writ petitioners, they have to pay court fee first.
Very good.
Therefore, after, my lord, I have come with the report, my lord. That it is a vested land. Plot number 976, 977, 1003 under all vested land. Your lordship kindly turn to page 6 to 9. My lord, the record of rights, which is annexed with this, সাবেক দাগ নাম্বার, প্রেজেন্ট দাগ নাম্বার, রায়তে পশ্চিমবঙ্গ সরকার পক্ষে কালেক্টর।
All are in Khotian one.
খতিয়ানওয়ার পশ্চিমবঙ্গ সরকার, they are from the collector. Government is a vested land, the land belongs to the government. My lord, the petitioners claim that the patta has been given to him in the year 1975-76. But from the searching of records from our department, my lord, it appears there is no such patta.
Page 20 of my writ petition.
No such patta has been given to any person. And the
Searching register ato, records available ato, no result as no document evidence was in favor of ato. Since no documentary evidence was available, his petition could not attend. And you have annexed your patta.
Page 20. It's a
Page?
document of 1978.
Page number
20.
very good. Then Mr. Bandyopadhyay,
my lord, from bottom, my lord, page 2 of report, last 3 line, it is also to mention that a copy of patta submitted by the instant petition WPA number such and such appears to fake and fabricated for the following reasons.
you have to come to a finding, sir.
My lord,
District magistrate has to come
finish,
to a
my lord. The serial number for the Rayati settlement of such and such, but it reveals from the office record that the Rayati settlement such and such not initiated in the year 1975-76.
No, sir, you come to a finding.
Thereafter, my lord, the office seal which has been used in the patta mentioned in the 2nd September.
I understand, Mr. Bandyopadhyay.
Hello, this
It
is
is just a minute, sir. just a minute.
My lord,
What I am on, it is your finding. But what I propose to do, that the district magistrate shall pass a reasoned order after giving an opportunity of hearing. Till then, status quo be maintained.
Kept open, my lord.
Absolutely,
My lord,
Uh-huh.
because, my lord, at that point
the
of time, he has used as a settlement SDLRO. But it has come out in the year 1883. We have annexed the relevant notification, page 10. There is no
Very good.
signature of SDLRO.
I understand. The affidavit of
So
If you
Malord,
avail
it
the
is not
train
required.
by
It
purchasing
is
one
not
ticket, all
required.
family members are going
It
there,
is not
that should
required.
not
It
be.
is not required. It is a joint cause of action, not required of it.
Will it dispose? Joint cause of it. Chalo.
Item number 15. Registered aye.
Yes.
Bengal,
Highways Act, 1960.
West Bengal Highways,
Yes.
1964. Removal of encroachment. কি হয়েছে গো?
But I'm on the state restaurant and with Mr. Tarok.
তোমার কাছে রাখো না।
Well, can you come to page
You are for
19?
the private respondent.
I am for the private.
Mr. Ganguly is for the state.
State, with Mr. Tarapal.
Tomorrow is the date fixed at 10:30 a.m. for removal of the encroachment in terms of the 10-4 order passed by the district magistrate.
Which
That
is
is
why
That is
it is taken today.
that is why precisely. Can you turn to page 19?
19.
19. At the instance of the private respondent, a writ petition was moved where it was directed to consider
Yes. Page number 19. Then what happened?
21, your lordship find to consider the representation and direct to take proceedings as a logical conclusion. Page 21 is the relevant portion.
Very good.
After that, my lord, notice were issued. I am drawing lordship attention to order passed on under section 10(1).
In one. Where is that?
Page 24, my lord.
While
Page 27, my lord, can you turn to page 27?
page 24 and 25,
Yes,
that is the order of the finding of the assistant engineer,
assistant engineer.
wherein on the basis of the demarcation report of the jurisdiction PLRO, he came to a factual finding
And issued
the
the order.
petitioners have encroached.
Yes.
So he placed the matter for the SDO for passing appropriate order for removal of the encroachment.
Page 27, my lord. Can you turn to page 27?
It is the order of 10-3.
Yes. Sub-regional officer, my lord, got it? The assistant engineer Canning, my lord, I'm reading one of the first.
Yes, sir.
Highway subdivision. PWD Roads has conducted a joint inspection with BLRO Basanti over the LS site of encroachment. Moja, such and such, Dag number 3610. LR Khatiyar number 4701. On such and such, following a notice was issued by the assistant engineer highway under section 10(1) of the Original Highways Act, followed by a hearing, such and such. Thereafter, issued a letter to the undersigned under section 10(2) by demo numbers invoking the provision laid down under section 10(3). Now, this was the adjudication made, and order was passed. So, presupposing this order, as per this order, that is relates to LR plot Dag number 3610. Now, my lord, can you turn to page 30? We prepared an appeal. Page 30, your lordship, right? Now, during this pendency, my lord, we got the report of the BLR. Can you turn to page 38? That, my lord,
Page number 38.
The BLLO being the assistant director, my lord, he is acting as an assistant director to the assistant engineer. In connection, my lord, got it? The honorable field inquiry of plot number 3610, Moja such and such, block number such and such. In connection with an order of the honorable district magistrate, by his office such you are requested to remain present on date on such and such for a field inquiry and demarcation with all relevant document, that is land acquisition map and land acquisition paper, smooth inquiry.
This has been issued during the pendency of the appeal.
No, these were there, my lord, at the time of TED 1, because these documents, I want to, because along with the appeal, these copies were there. Okay. Now, my lord, kindly turn to page 42. The report pursuant to is, my lord, SDO, I have brought your lordship attention to the SDO's order, one paragraph. From inquiry report, my lord, got it? From inquiry report, it is clear the report which was submitted by R.I. Shobir Mondol and Sagarmoy Mondol dated such and such, the plot number 3453 was mentioned as 3654, which was entirely a typographical mistake. The inquiry clearly reflects the encroachment has been made on plot number 3453. Besides the existing top maintained by PWD, classification plot number is Rasta in presence. 4 is very important. The inquiry has been conducted by using Moja map of the concerned Moja kept at this office because LMAP or document related to land acquisition has not been produced by PWD.
So Moja map is there.
Moja map, my lord, will not find. This is the state highways which the portion has been acquired. And our case is that it is the same authority is asking the assistant engineer to produce all these documents because, my lord, in a meter load, my lord knows very well than us, my lord, the two sides are kept for Doanjali, and if somebody wants to measure this from this side to that side, only the land acquisition map which can assure portion which comes in the purview of acquisition. These are the not.
Pursuits of a field inquiry has been conducted by. It's clear. Which has been submitted by order.
Now, my lord, kindly consider.
Just a minute, sir.
As your lordship. My lord, apropos to this, my lord, therefore, according to this report, the government land is 3453. My lord, got it? My lord, kindly apropos to this, my lord, kindly turn to page
3453. 3453.
Yes, now my lord, kindly turn to page 27, apropos to this. The order for recommendation or sub-regional officer under section 10(3). Yes, 27, my lord.
Hmm.
3610.
No, 3610 is his plot.
Yes.
Yes. 3610 is his plot.
My lord, all errors have been cured. There is
No,
nothing.
Then, my lord, if that be so, my lord, kindly, I am grateful to your lordship for. Then, my lord, kindly turn to page 38. Then, subject matter
Mr. Rai, no much golmal is there. No much golmal is there. Absolutely all right.
Pat on the point. Absolutely pat on the point.
See,
order under challenge.
yes, yes, I'm happy to that
It's a
also.
very crystal clear order.
Very clear.
Crystal clear order clarifying
My lord,
everything.
So I have on the basis that inquiry it was
No,
done.
no, absolutely. In absolutely
Really?
order. Take down.
No, I'm
My lord,
speaking.
hats
Apart
off,
from that,
my lord, hats off to
My lord,
the
I'm coming.
competency of my learned
coming.
senior friend, but nothing can be done at this stage. My learned senior friend has tried.
58. Can you turn to page
There's nothing
58?
irregularity.
I'm coming.
irregularity.
Sir,
Page
I'm not
58.
hearing any first appeal or second. It is a judicial review. You are to
These are
show
making process.
patent illegality
Yes,
and,
that is why page
and
58.
proceeding.
Page 58. After filing all this objection,
Uh,
I came before this honorable court. Consider my objection is not taken care of because there are proceedings for the hearing of the appeal without. Now, I can turn to page 58, the coordinate bench order. Page 59 is the relevant portion. In view of the above, well, got it? First, second, third paragraph. The Judicial Appellate Authority shall conclude the positive passage in order in accordance with the law on the basis of the plea already taken by the parties thereto before it, and same on the hearing on the extended date, such and such. So this point which I have raised has to be dealt with by the district magistrate in any manner whatsoever, rightly, wrongly, whether such dealing was there or not.
what point?
First, yes, I made the objection. Well, I can turn to my appeal. Page 61, P9. হ্যাঁ বলছি তো appeal dispose of
Coordinate bench had only directed the authority to dispose of the appeal under 10-4. That has
not
been
only
done.
that, taking into consideration of the plea raised. Now, my lord, can you turn to page 76, the order passed by the appellate authority.
Kindly browse over the lines of district magistrate's order, that is
Page
under
76.
the challenge at page 76.
Yes.
Nothing remains, nowhere he is affected. Landing question is 3454. 3610 is nowhere.
That has already been clarified by the district magistrate in no uncertain terms. It is very clear. Page 76 and 77 is very clear.
Now, my lord, can you turn to the findings of the appellate authority. Page 77, for 3 lines.
Before that, my lord, you kindly read over this 76.
76, 77 is fine. Lord.
77.
From page number 61 to what do you want to show?
Page 61.
From page number 61?
It's the appeal, the grounds which I have taken, that your lordship find from 2A onwards. These are the points regarding the objection which I have taken.
What is the bone
One objection is that in absence of LMAP, it is the authority who have asked for the same, not produced. It is not me which I applied for the same.
LR porcha is the LR record is there.
Moja map.
LR record is there. It is in Khotiar number 1. It is classified as Rasta.
Therefore,
Everything is there.
that is why, my lord, whether these shops are there on suggestions or not.
It is finally published Moja map. Finally published Moja map.
Yes.
LA map is not required at all.
Then, my lord, the authority, the person who is conducting the inquiry is on that basis. And that is why if your lordship
The plots are numbered.
Yes.
The error has been cured. It has been clarified in page 42. Nothing. There is a
That
very
is why-
clear
where is the
clarification
adjudication?
with
I
regard
have
to
raised
42.
an irrelevant point, my lord. Can you consider that? itself?
Kindly
Then, my
appreciate.
lord, where is the adjudication of the DA?
Mr. Rai, you know better than me. In a judicial review, a writ court cannot
Go into the.
reweigh the evidence.
I'm not on the evidence.
Even if the authority come to a finding on the basis of the materials available before him, even if the same is not acceptable to the writ court, the writ court has no jurisdiction to entertain unless you show that on account of non-consideration of the materials, the decision-making process has been violated.
Yes, page 77.
And my lord, one
Page
very
77. Let me complete after that, my lord.
He is trying his best because tomorrow is the date of eviction.
Page
Yes,
77.
on before your lordship.
Well, this is the adjudication of an appellate authority, 3 lines.
admitted position and we keep it admitted position.
So the CC 10 কোনো ফাইন ফাইন নিউশন তো I should take down.
My lord, just 3 lines, my lord, may I point
I
out?
go against you.
My lord, I beg
My
to
lord, I
appear on
15 on
behalf of the
petitioner.
respondent number 9.
My
My
lord,
lord, an allegation has been raised against us.
my lord, as per
for,
court direction, my lord, I served notice upon all, my lord.
Yes.
This is the affidavit of service.
My lord, allegation has been raised against us in the writ petition that we have.
The private respondents?
Yes, my lord. 9.
My lord, this is the demolition of
What about
illegal-
8?
illegal encroachment by
We are not representing.
private respondents. I given representation page number 20, my lord.
We are not representing 8. My lord,
You have served respondent number 8?
Yes, my lord, 8, 9 both.
Where is that, sir?
I have given.
Hey, the,
8 is relative. 8 is also relative. Relative, but
give me a
not
second.
here. Maybe. Respondent number 8 has been served. He's my
Yes, sir.
he's my relative also.
Yes, he is pretty, sir.
I have
Yes.
given representation for demolition of unauthorized encroachment, my lord, page number 20. But that has not been considered, my lord.
Very good.
My lord, may I?
Let them consider.
No, my lord.
Why not?
All applications, my lord, subject to corrections, my lord. All applications cannot be, my lord, directed to be considered unless it satisfies the minimum requirement.
Yes,
May I
sir.
submit that? My lord, may I hand over first regarding the mental ability. My lord, what he says in the writ petition in para 4, page 5,
Yes.
that the petitioner states that due to progress of his present business, he is going to construct a building on the above stated royalty land after getting permission from the appropriate authority and going to make development for the purpose of family business. So appropriate authority, he obtained permission from the appropriate authority for making construction.
Yeah.
And now, my lord, first, my lord, I am giving the photograph. This is a pond, my lord, water body. He is raising construction. Where is his permission? First, suppression of material flag. He is not coming with the clean hand. My lord, kindly have a look to this photograph.
But unfortunately, private respondent number 8 and 9.
I will come on that.
The unauthorized illegal park structure.
On that I will
Common
come.
land. Oh, that is on the abandoned
Whether-
portion of PW road. Department by covering the front
My lord-
portion of the above stated.
My lord, on rest part I will come.
Members are facing much problem.
My lord,
Rest
they-
part I will come, my lord.
they
That
have
will
the
not the
access
that
to
is
before
not
the
the
appropriate
that
authority
is
against
not
me, my lord.
that is not the government land. First, that part I will come. I will satisfy. It is his construction, my lord. Kindly have a look. It is water body without any conversion. On the water body, he is raising
Another cause
construction.
of action. If he has any allegation,
He has to
against me,
come.
he has to go before the appropriate authority, my lord.
In oath, on oath, my lord, he is saying something that obtaining permission, he is making construction. He is coming unclean hand, suppressing material fact. He is trying to obtain an order. This is first part, my lord. Regarding the encroachment, my lord, say that we are on our own land. I will demonstrate that. I have the documents. Now, my lord,
Okay, what is the nature of your land?
Jol. I am giving. My lord, kindly have a look to this Mauja map. The difficulty is his land is the last land of his Mauja, and our land is the first land in other Mauja. Amar copy to My lord, kindly have a look to first page. My lord, I've indicated.
2834 and 2835.
Yeah, first page. My lord will find Mauja God Moina. My lord, in top Mauja God Moina. My lord, I have indicated. Kindly excuse my lord. Our plot number is 121. I have indicated in the pencil, my lord.
Yes.
It is our plot. After our plot, my lord, will find in the left hand a road is there, my lord, in the map.
Yes.
And now, my lord, now come to page 4. Page 3 is the Mauja map portion. It is, my lord, it is small size. So I have in page 4, my lord, I have enlarged the Xerox, my lord. Page 3, my lord. My lord, got it, my lord. First page, my lord, kindly once again come,
Yes.
my lord. This is our last plot of the Mauja. This is Mauja God Moina, last plot. After our plot, a public road is there. And my lord, if my lord comes to page 4, I have marked
2384.
in the bottom, my lord, his plot number is 2384
2385.
and 2385. Last two plots from the bottom of the another Mauja, Chongra. Ki Mauja no? Chongra.
It is enough. It is enough.
My lord got it?
Hmm.
And
Page 5.
page 5 is our record, or our record in the name of our predecessor. Plot number 121, my lord got. And my lord will find in the left hand side, road is there. In the bottom, road is there. And our land is 121 Moja Gormoyana. And page 6, my lord will find their land. My lord, kindly have a look to the page 6 once again of the branch, last page.
Sir, I have seen, sir.
Oh, last page.
It is classified as John.
Not only Jol,
John.
after his land, no public road. Page 6. This is Moja concern plot number.
This is the subject to investigation, my lord. BLR has been added party, my lord.
Each and every matter cannot be, my lord, directed to be. Let him first submit with some documents by supplying some maps, something. And that too, my lord, suppressing of material fact with coming with the unclean hand, saying, obtaining permission, I have passed.
I understand. Listen to my order. The
My lord, I wanted to show one judgment of our division bench, wherein, my lord, it says for personal interest, my lord, the order in the writ petition. Yes, yes, yes. Grateful. Yes, it is. I said, my junior, you want to show this judgment, other matters will be grateful, my lord.
Call the list.
My lord, may I mention, my lord? My lord has asked me to mention at 2 o'clock, my lord.
Yes, yes,
My lord, here, my lord, there is an extreme urgency. The urgency is this, my lord. As per the section 161 of the LR, there is a provision to the Tahsildar has the power. Within 2 years, if the tenant is dispossessed, the Tahsildar has the power. What the Tahsildar has done, he has given the stay order on 22nd of May 2025 by stating that
Madam, bench is not available at Andaman.
no, my lord, no, my lord. That's the difficulty. Now what happened, my lord? They have started construction. I have already filed the writ, my lord. If it is sent through, my lord, it can be taken up tomorrow, my lord, because I have already given the notice also, my lord. Notice also, my lord. Kindly, my lord.
Tomorrow. Raniano. It has been sent.
No, my lord. The approval, my lord's permission is required, my lord. An order is required. That's why, my lord.
What is the urgency?
Urgency, my lord.
Construction is going on.
Now construction is going on still. Because once they have vacated, they have, in the order itself, they have mentioned until demarcation, it is there.
Tomorrow at 2 p.m.
My lord, I highly oblige, my lord. Highly oblige. Highly oblige.
ওরা পাঠাবেন ওখানকার রেজিস্ট্রি থেকে পাঠাবে আমাদের কাছে
Highly oblige, my lord.
রেজিস্ট্রি থেকে পাঠাবে আসবে 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 পাঠাবে নাম্বার হয়ে তবে তো আসবে Yes, call the list. Review matter, no?
May I please, your lordship?
That yesterday,
Yesterday, Mr. Bandyopadhyay has concluded the submissions with regard to review. Your lordship has taken notes.
Yes, yes.
Then my learned senior friend may.
File done.
may it please your lordship.
Yes, sir.
Yesterday,
এই পেপারবুকটা দেখি
paper book ta din Joshua.
পেপারবুক
Yesterday, my learned brother, Mr. Bandyopadhyay,
আরেকটা আছে ওইটা যেটা নোট করা আছে দেখুন না থ্যাংক ইউ
yesterday, my learned brother, Mr. Bandyopadhyay, very artistically, I must appreciate very artistically tried to pursue the lordship. 3 or 4 points which warrants review as per his submissions. Firstly, although in disguise he has argued the matter on merit, but before going to the technicality, kindly permit me to meet the points he has taken. Firstly, as I have understood, subject to corrections by your lordships. Firstly, he said that the notification by which the petitioners were appointed, as per page 33, there and the terms of appointment letter also stipulates that we are only eligible to get the remuneration which is prescribed there, and no further remunerations will be there. This is number one. Secondly, his submission was that your lordship, in the judgment sought to be reviewed, held as if your lordship's observation is that the memorandum of 2011 appearing at page 50 has been given a go by. And your lordship, before your lordship, this was pointed out, not pointed out the specific clause 5 and proviso, which says that
in addition to the restrictions of not having continuous service of 10 years, the candidates must be appointed before 1/4/2010. Proviso 5 at page 51 has been heavily relied upon by my learned friend. But his submission was that if the candidates are engaged after 1/4/2010, then the benefit of section 2011 memo appearing at page 50 and the subsequent circulars or notifications appearing at page 57 and 59, that benefit should not be given. First, that criteria, that hurdle is to be not crossed. That was his basically main submission. Now, before going into that, I'll rely on their own documents that this submission is absolutely not sustainable. But prior to that, kindly permit me to place just the memorandum, 3 memorandums, which were considered by your lordships in detail in the judgment. But still, since my learned friend has tried to pursue your lordship, not kindly permit me to place 2 or 3 clauses of the 3 memos. Firstly, not page 50. Page 50 is the parent memo, 16th September 2011. Your lordship knows that prior to not coming of this particular government, the earlier memo was 23rd April 2010. That was an earlier government memo. Now, this memo, for the first time, has given some benefits to the poor temporary contractual workers and casual rated workers who have been subjected to, not if I may say so, kindly pardon me, that they have been subjected to exploitation by the state even. So the first time the government has taken a policy, but I must appreciate that since the state doesn't have enough fund, so the opportunities have been given to engage the contractual employees, although those have been deprecated in this circular Solstein and Umadevi judgment, your lordship knows. But still, in the entire country is going on this engagement of contractual level. Because of the fund, I appreciate that. But the state, as a welfare state, I welcome that, have taken a policy to give some, at least some minimum benefits, that's the minimum pay band, that your lordship it will find that last clause of that page 50 clause II. This is the minimum pay band and some amount after retirement, and the tenure of service would be up to 60. There are different clauses, some restrictions of less than 10 years, but less more than 10 years that should be there. But there are also clauses providing some benefits in case who are working less than 10 years, that is also provided there. Kindly comes to clause II, which says that minimum pay band at page 50. The entry point basic pay rupees 6,600 will be admissible to casual rated contractual group D workers. And I did not trouble your lordship that. That is there. Then clause III, when casual designated contractual workers are allowed entry point, they will not get any other allowances like dearness allowance such and such for the period such and such. Remuneration, not clause 4, I'm not relying on clause 4. The remuneration of casual designated contractual workers who have not yet completed 10-year service will be equivalent to 75% of the remuneration. So all these clauses are there. Then my learned friend relied on this clause 5. Kindly pardon me for repeating this clause once again. This is heavily relied on, and as per my learned friend's submission, that this was not pointed out, and that's why this is apparent up under the face of the record. This is the clause. Those casual designated contractual workers who will complete 10-year service on 1st July every year will come under the purview of this order, provided that no such worker, if engaged after 1/4/2010, will come under the purview of this order. And it is also not important to note clause II. I am leaving other clauses. So many clauses are there. Page 52, Roman 12. The benefits of this memo will be applicable mutatis mutandis to panchayat bodies, ULCs, statutory bodies, efforts. But in several litigations before this court, that when different departments appointed temporary casual workers under different notifications, but parent memo is the finance. If the finance approved it, definitely there will be separate notifications. So stand was taken on behalf of the state in different proceedings that since the finance memo is there, this department has not adopted this finance memo or issued separate memo. So benefit of finance memo that should not be given. That was the stand. But unanimously, the coordinate benches of your lordship and other courts not held that this particular memo and subsequent memo modifying and giving more benefits that should be applied and given to all candidates of all departments. Because this is the government policy, government has taken this position and finance is head, but there should be uniformity of adopting the policy and applying the policy to similarly circumstanced candidates on the basis of doctrine of equal pay and equal work. Now, this particular clause is there. This is heavily relied upon, clause 5. Now, kindly comes to page 57 and 57 first. Now, just simple back calculation, although this is my management submission warrants the detailed reasoning, elucidating the points, which my lord has already considered. But still then, since my lordship has taken as this point, but I must satisfy your lordship on this. Kindly comes to page 57. But page 57 and 59, and even there is on record a circular of 2025, always in the first paragraph, they refer to the circular of 2011. My lord, kindly comes to page 57 once again. First paragraph. In this department number such and such 16/9/2021 to 2011, it was decided to allow appropriate amendments, security of tenure, such and such. So the parent memo is there, giving some benefits. Now some in modification of that, some additional benefits are there. And the terminal benefits, medical benefits, everything is there. Kindly comes to page 51 once. The last clause, 58, I'm sorry, 58, the next page. This will take effect from 1st of March 2016. Now this circular. Now, kindly comes to the clause, the chart less than 5 years and 5 to 10 years at page 57. Has your lordship got it? Kindly comes to less than 5 years. So less than 5 years, this circular is effective with effect from 1st of March 2016. Now, if my learned friend's contention is correct, then if we go back 5 years from 2016, it cannot be prior to 2011. Now, if a candidate, as per my understanding submission, appointed prior to the cutoff date which is mentioned in page 51, that is 1/4/2010. My lord has got page 51, clause 5, which is the basic contention, main contention, learned friend, that the candidates should have been appointed prior to 1/4/2010. Has your lordship got it? Now, simple back calculation of 2016 circular, that if a candidate, if he is appointed prior to 1/4/2010, he will be definitely more than 5 years. 2010 to 2005 years, April 2015. Effective, this circular effective is 1st of March 2016. So to get the benefit of this circular of that less than 5 years, the candidate must have been appointed after 1/4/2010. My lord, just may I explain that? 2016 circular, March 2016.
2016 circular takes effect from
1st of
March
2016. Now,
if I go,
yes, then
less than 5 years,
then I come to back 2015 1 year, 2014, 2013.
Then it must be
After
1st March 2011.
Yes, 1st March 2011. So that contention, if that contention is correct, then less than 5 years, this chart would have been OTOs, redundant.
Marker you engage after 2010 will come under the purview of this order.
So that was prior to this issuance of 2016 circular. As on the date of 2011 circular, that restrictions was there. But by issuing this circular and a subsequent...
Whereas, I understand your contention. Listen to me, Mr. Dhar.
My lord.
according to you, according to Mr. Bandyopadhyay, sorry, 2011 excludes those persons who have been engaged after
After-
1/4/2000.
Absolutely, 2010.
So if we keep that as a constant,
Yes.
and if we look to the circular of 2016, it says it will take effect from 1st March 2016.
Yes.
It categorizes a person of less than 5 years.
5 years.
So, as on 1st March 2016, if a person claims under first row,
Yes.
less than 5 years,
Yes.
he must be appointed after 1/5
Bow down. I bow down.
2011.
Yes, I bow down. So that was the intention, and that's why your lordship in the judgment under Sattu review said
It has been given a go by.
go by. That particular entire circular has not been given go by your lordship's order. That particular restrictions of firstly 10 years service and this 5 years and 6 years, these restrictions, rigorous restrictions has been go by this simple back calculation. So a person, even in appointed 2012 February, 2013 February, 2014 February, and 15 February, they also come under this clause. Less than 5 years, even 1 year, appointed in 2015, also entitled to get the benefit of this first clause. And even second clause also. সেটা তো পরে আসছি দাঁড়ান না এইটুকু। Next page 58, paragraph 4, clause 4. The governor has been pleased to decide the high power committee will be formed to review the conditions of their engagement and for suggestions as to further improvement. So, my lord, I would say that as a welfare state, the government has formed a high power committee to review the situation because of the increase of the cost of living and cost of living index. My lord, there will be further remuneration. That option was open, kept open by clause 4. Now, the similar contention kindly comes to page 59. This 2019 circular.
Mr. Dhar, give me a second.
My lord.
Mr. Dhar, I'm asking 1 second, one question. Please come to page number 51 and 57.
Yes.
Let us take an hypothetical situation.
Yes.
Suppose a person is appointed. Take an hypothetical
My
situation.
lord, my lord.
Suppose a person has been appointed on 31 3/2010.
31/3/2010. He will also come.
He will also come under
He will also come.
2011
Definitely, definitely.
because the cutoff date is after. Or as on 1/4 it will affect. So if I take on 31st March as a constant, and if
he come to the next clause 10 to 15 years, 15 to 20.
I understand.
That's why that memo is referred.
It is affected on 1st March
2016.
2016.
Even there is a circular 13 also. I'm not referring to that. They will come under next 10 to 15, 15 to 20 as per their engagement. That's why 2011 circular mentioned in every these circulars. Because a person who was appointed in 2005, his 10 years will be 2015. He will come
Give me
to
a second.
my lord.
For the sake of argument,
My lord.
if any person is appointed on 31st March 2010,
He will come to the next clause 10 to 15 years.
sir, I am not on that.
My lord.
And if this notification is taking effect from 1st March 2016,
16.
so as on 1st March 31, his tenure of service will be 5 years, 11 months.
If he is engaged in 2000,
If he is engaged
31st,
on
yes, yes. Yes, yes.
6th March 2016,
Yes. Then he will be entitled to
And-
get, yes, yes.
I'm sorry, if he is engaged on 31st March 2010, and if
5
this
years.
notification is
16.
1st March
He will
2016,
come to the next category 10 to
so his tenure of service will come for 5 months, 11.
5 to 10 years, next category.
5 to 10.
So he will
Then
get
I
the
believe your contention is that, and if a person is appointed on 1st April, then his tenure will come under the category of his tenure will come for 5 years, 11 months,
yes,
1 day.
yes.
So it
Then
will come
his
under
pay
5
will
to
be
10
yes. His pay will be
Then-
revised.
Then I
His
believe
pay
it
will
is
be
your
revised.
contention.
Yes.
There's if such be the contention that if a person is appointed on the cut-off date, his tenure of service would come under the second row.
Second no.
Then what is the necessity?
Yes,
that
yes. I
including
bow down.
first row?
Yes.
That is
It
your
would have been,
contention.
yes, yes. It would have been redundant. Because of that, rigors has been relaxed by this notification. So persons who was appointed even after 10/4/2010, he will come under the first category, even appointed in 2015. Simple back calculation. Otherwise, it would have been redundant. Similarly, kindly comes to page 59.
Some minimum arithmetical calculation is required for the political fraternity.
Yes, my lord. This is bare, my lord.
Very good, sir.
My lord. Then 59. Lord, the similar first paragraph, I not traveling your lordship. In the first category, 5 years. This notification of 2019 with effect from Lord 1st February 2019. So if I go back 5 years, then it will come to 2014 onwards. A person appointed in 2014, 1st February 2014, after 1st February, he will come under this first clause, even 2015, 2016, 2017, 2018 also. So a person appointed after 1/4/2010, this submission is absolutely untenable because of these circulars. And I will also readily show they have given similar benefits who were appointed after 2010. This is their document. And my lord has noted that. But the same submission with regard to the page 59, that a person who was appointed after the cut-off date as per 2011 memo, they are even eligible to get the benefit under the first table, even group C and group D both. So a person, if I go back to 5 years from 2019, even a person appointed in 2018 also will get the same benefit. But am I clear to myself, Madam?
I understand.
Madam.
It is your contention, had it be the intention of the model employer
Yes.
to stick to the
That part of it.
2011 notification,
Yes.
there must not be those rows
Yes.
which have been started with the words less than 5 years, 5 to 10 years. This is your content.
Absolutely, Madam. And the similar notifications also page 62, which at the time of hearing that I prayed also for this, but your Lordship did not accept my prayer. Your Lordship directed to consider similar notification page 62 also. It's less than 5 years. It's a notification dated 15/7/2019. Now, Madam, very interestingly, they have also realized that these will not kindly visualize that these bare minimum salary of 3,000, 1,500, 5,000 appointed in 2018-19. One was appointed in 2013. That the minimum wages at least 400 to 500 rupees. But I must say that
is different.
But that was the circular. That's why I welcome.
You.
No. Yes, that's why my learned friend made submissions.
Mr.
Yes,
Bandyopadhyay,
yes,
Mr.
this is.
Bandyopadhyay's
But I understand.
contention was
Yes,
purely limited
that
for
cross five provision.
non-consideration of
Cross five provision.
2011
Absolutely.
while passing the judgment.
My lord. Kindly comes to then, my lord, the similar type. I say that the government has realized that mistake. But I welcome these decisions. Kindly comes to page 205 once again. The similar benefit, and this is also important, page 205. This is the circular notification dated 1st March 2024.
205.
Yes, 205 of the paper. But this is very interesting. 205. Typed copy is 205A. Better your Lordship kindly comes to 205A. The bottom portion is illegible. This is very important. First paragraph in the same line referred to 2011 circular. First paragraph. As your Lordship got it. The question of embarrassment was same in the same line. Then, my lord, kindly comes to the first. On initial engagement, the state thought it fit that the initial engagement, the remuneration which was payable to Group D and Group C, there was very less. That's why from the very initial stage, the state adopted the policy, minimum remuneration should not be less than this. Now, this is why I said this is important. Last paragraph, bottom. What is the cut-off date there? Cut-off date, your Lordship will find all enhancement up to 1/7/2000 shall be allowed after such revision to all contractual workers, excepting who had engaged after 1/4/2004 for is completed after such and such. So, candidates were appointed 1/1/2024. If I go back to 5 years, even then, from 2024-2019 appointed, they will get the benefit of this circular, 2024 circular.
You have been engaged after 1/1/2020.
They will not get prior to 1/1/2024. May I just read that? Annual increment on such and such shall be allowed after such revision to all such contractual workers, excepting those who have been engaged after 1/1/2024. So, cut-off date to calculate 5 years, 1/1/2024. Even I go back from 24 to 5 years, it will come to 2019.
Enhancement on 1/7/2024.
Yes. So, this is also the initial.
Where from 1/7/2024 comes?
Mother?
1/7.
The annual enhancement, because every July, there is all these circulars, annual increment will be the 1st of July every year, all these circulars. So this annual increment,
It was with effect from 1st April 2024.
no, annual increment was there in the earlier circular also. By virtue of this circular, in these cases, the annual increment is referred to. So government is modifying, giving more and more benefits. And here the cutoff date, my contention here is that the persons who were appointed and whose service is 5 years or more, as on 1/1/24, will come under the zone of consideration of according to this notification. So my different contention, when here 24, so 5 year we go back 2019. So 2019 person appointed or 2018 appointed, he will get the benefit of the second column, 5 years and initial engagement. And this circular also refers to 2011 in the first paragraph. So the restrictions of cutoff date that persons engaged after 1/4/2010 will not come under these benefits. This is absolutely redundant. This is not tenable submissions. Now, my lord, in fact, what has been done? Kindly comes to page 57 of the writ petition. They have themselves given this benefit who were appointed after 1/4/2010 in a similarly circumstanced candidates and other candidates also. Kindly comes to page 57 of the writ petition, which they have not included in the paper. Included? Not included in the paper. দেখো এটা এটা না না মাঝখানে মাঝখানে আছে হ্যাঁ বাকিটা আছে এটা দেয়নি জজ সাহেব কিন্তু রিট পিটিশনটা বাদ করে দিন না ম্যালট হ্যাজ গট দি রিট পিটিশন আগেরটা সার্কুলার 2019 সার্কুলার
এই রিট পিটিশনটা কোথায় আছে গো?
একটু রিট পিটিশনে জজ সাহেবকে খুঁজে দিন না
এটা তো রিভিউ যেগুলো ক্যান এর সঙ্গে একটা ফাইল
বসুন
ওইটা বার করুন, ওইটা দিন।
Understand this will continue. Today is
But I'll cite some authorities also, but that's why not may continue. Today is
Today is 3:30.
It is only 236.
He will continue.
আর বসো না যদি শেষ হয়ে যায় যদি জজ সাহেব অ্যালাউ না করেন আমাকে পুরোটা সব দাঁড়ান
Yes, Mr. Thor.
58 হ্যাঁ 3rd April 2009 that has got the writ petition and he comes to page 57. This is the legible copy, somewhat illegible. It's a copy now. Legible copy. Mother kindly comes to serial number 4. Mother kindly take the legible copy. I have just handed up. Serial number 4. Parboti Mondol. Parboti Mondol, matron, date of engagement in 6/8/2012, after 1/4/2010. Kindly comes to the first paragraph. In pursuance of the Finance Department's memo number 8/2019, this is this circular benefit your lordship directed. 8/2019, the governor has been pleased to accord approval to allow appropriate emoluments and other terminal benefits in terms of Finance Department memo dated 16/9/2011 and subsequently modified by memo dated 25/2/2016. That is another circular that I am claiming. In favor of 5 caretakers, 4 matrons engaged in contractual basis, regular sanction post working in different categories with effect from 1st April 2019.
These persons have been appointed under the same memo.
No, they have been appointed not either 2011 memo. Subsequent memo.
No. Mr. Bandyopadhyay yesterday argued that their terms and service terms and conditions of the services will be governed by the relevant memo.
Relevant memo. Now, this is not that. This is not that. But I wanted to say here, to buttress Mr. Bandyopadhyay's contention, a person who was appointed in 2012, not pursuant to the 2011 memo, a person appointed in 2012, not by virtue of 2011 memo. My learned friend says who are appointed in 2011 memo, they come under the benefit if they are appointed prior to 1/4/2010.
No, it is the further submission of Mr. Bandyopadhyay.
Yes.
That they are
Different. When I say, yes, 18, 2018, 16.
19/6, 2019.
2016, 2018. 2016 initiated, 2017. And thereafter, 2018-19 appointment was given. My learned friend's first contention was.
Give me a second.
My lord. Mr. Bandyopadhyay's contention in that we were recruited pursuant to a separate memo, so you do not come under this. We are not eligible to get the benefits.
Yeah.
But my contention, I have authorities that initial finance memo issued the memo in 2011. Then there is a circular 2013, then 2016, 2019. All these are the parent memo of the finance department. Different departments under the different wings of the government that issued separate memo for recruitment. So that conditions mentioned in the separate memo or appointment letter, that cannot curtail my legal right of Article 14(16) for equal pay for equal work. Different government may have, different wings of the government may have issued. Separate memo was required for recruitment, taking the approval of the cabinet. But that condition that I will not get more salary than what is mentioned there, I will not get regularization, these cannot curtail my legal rights. If I come under the zone of consideration as per exception to memo Uma Devi's judgment, even I can claim regularization. So if the similarly circumstanced persons working in the similar types of post are getting more salary than me, then I am legally entitled to get those salary as per the doctrine of equal pay for equal work, which has been recognized by your lordship following the Ranbir Singh judgment and the other court benches. So whatever they write as a state, I am in a recipient situation. I'm a poor person who is dearth of employment. I get the employment. That is, I am not bound that I will not get more salary and my salary will be stagnant as per the initial memo by which I was appointed. This submission is absolutely not, if I may say so, with greatest of respect to my learned friend, that this is not as per according to the law and this violation. Yes, my lord.
If I look to the provisions of Article 14, you have to, in order to get the benefit of Article 14, you have to establish a case that by issuing this memo, an endeavor has been made by the state to make an unreasonable classification amongst the same classes of persons.
Yes.
Then Article 14.
Absolutely.
In my understanding.
Absolutely, Mother. I bow down. I bow down. Now here.
In this memo, the persons have been appointed in the post of matron, caretaker.
I'm also matron. One of the candidates matron. So these are the.
No, you are the superintendent.
And also, not on different posts. Helper, cook, matron, supervisor, everywhere.
Where is matron?
No, this is matron page that here my
page 34.
In the Parvati Mondal page that I am referring 57, matron Parvati Mondal. She was appointed in 2012.
No, in your case.
When I'll come. I definitely will come. That my first and foremost submission is that the government as a welfare state had issued these 2013 memo, 16 memo, 19 memo, 2024 memo to apply to all contractual and the designated workers. So these designated workers of different wings, their classification cannot be come in the same way. But nature of duty of caretaker, matron, there cannot be same. But the government's department that applied those memo to all workers who have been engaged in contractual labor. I will cite the decisions. I have the authorities. And the government has adopted that. So there is no dispute about that, the application of these benefit, extending the benefit of these circulars. And my petition kindly comes to page, the post, page 156. 156. This is
The
their
read petition. Of the read petition.
No, paper book. Paper book. Page 156. Mother, can you see? The designation, first petitioner, caretaker. Your Lordship will find on page 57. Can you compare it with page 57 of the writ petition? Then superintendent. Has your Lordship got it? Page 156.
Yes.
The first person's designation is caretaker. Then superintendent. Kormobandhu matron. Your Lordship will find matron. Serial number 4. Page 156 bottom. Your Lordship got it?
Yes.
Then drawing come night guard Darwan helper. And compare it. This is just in one instance. I have other instances also. Kindly compare it to page 57 of the writ petition, which I handed up a separate copy. Caretaker matron is there. Three caretakers, one matron in that memo of by which 2019 benefit given. As your Lordship got it. The first
9,000, 115,000.
Yes. That is the first paragraph, topmost paragraph will transpire that the benefit of 8 February 2019 circular given to these persons. First paragraph of that page 57 of the writ petition, separate page, first paragraph. The benefits of 8 February 2019, which my Lord has been pleased to give us, that benefit has been given to these persons. Out of these, one is appointed, Lord, after 1/4/2010, which my learned friend has said that it, first paragraph, Lord. When this 2019 circular came, that is 8th of February, immediately on 14th of February, the benefit is given to these persons. And I am relying on clause number 4, the person who was appointed in 2012, after the cut-off date has mentioned 2011. My Lord has got it, my submissions. I wanted, my respectful submission is that a person, my learned friend contention that a person appointed after 1/4/2010 will not get the benefit of these circulars. This is absolutely contrary to this document, which is part of the record. And my Lord has consciously considered this document. When I go through the judgment by your Lordship observed that similarly circumstanced persons have been given benefit. Can you see this? Since this point has been taken, can you see this circular also by them? Can you come to the second page? This is the of 2011, giving the benefits of 2019 circular. First paragraph, your Lordship will see subject proposal for sanction of benefit. And your Lordship kindly comes to serial number 12, 13, and 14 in the next page. Serial number 12, 13, and 14. Serial number 12, night guard. Date of appointment 3rd of October 2016. It was not there. Since this point has been taken.
Beyond the paper.
No, beyond the paper. Your submission was new submission. I must point it.
Very well. New submission. I show.
This is your document.
I show from the memo whether new submission.
Yes, yes, yes. Let me finish.
No, but
so this is admittedly their document. Page number 12, 13. They must not suppress. They must not.
No, I understand.
Page 12,
part of the evidence.
Yes, and I cannot be taken by surprise by suddenly pulling
No,
out
then
the
I can
document.
file the affidavit. If I
No, you have
no. You have also included so many documents which are not part of the record. I can show this. So this is admittedly in 2016, night guard peon helper, they have been given the benefit by this 2005.
So far my recollection goes, it has been shown to me.
Yes.
At the time of hearing.
Yes, that's why your Lordship observed that similarly consciously. Now kindly comes to, allow me to place your lordship's order, whether my London's submissions warrant the detailed elucidations of the points, or whether this is a mistake absolutely apparent on the face of the record. On the face of it, your lordship will find it there is a mistake, or my London's submission needs elaborate discussions on the point. And if it needs elaborate discussion, review is absolutely not maintainable. I have some of the I'll heavily rely on. But prior to that, kindly permit me, your lordship has considered these points elaborately. These documents were cited by Mr. Basu, who was there. The change of counsel and making new argument will not warrant review, subject to corrections. And this is not, I must say that this is unfortunate. A state depriving the benefit, keeping the workers at a minimum bare salary of 3,000 and 4,000. Kindly comes to your lordship's order, page 80. Kindly permit me to place 2 or 3 pages, which my learned friend entire submission was as if by your lordship's judgment, your lordship held that the 2011 notification has been given go by. No. My respectful submission is that on a plain reading of your lordship's judgment, it says that the rigors of continuous 10-year service that has been given go by because of this first clause 5 to 10 years. 2011 circular still remains. Kindly, yes, my lord. Kindly comes to now. So my lord has recorded these remuneration at page 82. Then kindly comes to page 5. That is circular of 2011. Page 85, internal paragraph 5. Page 82. Page 82, my lord. That before going to the reading of the submission, my submission is there. A circular has 15 or 16 clauses. This circular was referred to by me as well as Mr. Rajarshi Basu as appearing on behalf of the state. Now, if a particular point is not considered by the lordship as content, which is not correct, I will say, then another review will be coming that this particular point was not considered. Presumption is that entire circular has been considered by your lordship. Kindly place, allow me to place paragraph 5. Drawing attention to annexure P2 at page 46, being Government of West Bengal Finance memo number such and such. This is the 2011 circular. Notification number such and such 2016. Notification number 8 to 2019. It is contended by Mr. Dhar that those state respondents that duly considered emoluments and benefits of the contractual employees are meager, and thus issued the aforesaid 3 notifications time to time to revise the benefits for extending the same to casual designated contractual workers who are working in different departments of the state respondents. For the reasons best known to the respondent herein, such material financial benefits have not been extended in the case of the petitioners in spite of making several representations. It is further contended that similarly, this was my contention, similarly circumstanced contractual employees in other departments, even in OBCW department, have also been extended the benefits of the phase 3 notifications. It is thus submitted on behalf of the petitioners that the aforesaid action on part of the state respondent violate the principle of equal pay for equal work under Article 14. Then, my lord, I cited Ranvish's judgment, I skip. Then, my lord, kindly comes to the contention made by Mr. Basu on behalf of the state. Paragraph 8. Lord, kindly permit to place up to page 89. This entire picture will be clear that your lordship has considered so many points. Paragraph 8. Per contra, Mr. Basu, learned advocate for the respondent state, at the very outset submits that since petitions are working different posts, this contention was that a single petition should not be filed. There, your lordship directed me to pay the court fees I have paid. This is not required for the present purpose. Paragraph 8-9. Lordship kindly skip over. Kindly comes to page 85, paragraph 10. Oh, yes, miss. My paragraph 9 also, my lord. Page 84, yes. Paragraph 9, my lord. It is further submitted, Mr. Basu, that from annexures to the writ petition, it would reveal that period of employment as contractual basis of the present petitioners are less than 10 years. Even in the writ petition, they have stated that they have rendered 10 years of service is contrary to truth, and for wrongful statement, the petition should have been dismissed. Paragraph 10. In course of his argument, this is very important. I heavily rely on this paragraph. In the course of his argument, Mr. Basu also presses his reliance upon notification number such and such as issued by the finance department. this statement does not show that he only relies on paragraph 1. He places the entire notification and presumption that your lordship has considered the notification. It is argued by Mr. Basu from the very first paragraph of the state notification, it would reveal that respondent state while issuing the state notification for modification of the amendments of the contractual designated employees have considered those employees who can come under the zone of consideration. So zone of consideration, that cut-off date is also there. When state submission is that the petitioners do not come under the zone of consideration of this notification, that presumption is that your lordship has considered the entire criteria of coming into the zone of consideration and within the purview of notification. But if by of illustration and relying on different clauses, this review is not permitted, then definitely there is floodgates of review. This is not the principle which is not followed and accepted by the Supreme Court. Supreme Court deprecated this practice. I rely on this judgment. So zone of consideration, I heavily rely under the state notification, who have worked for a considerable period of more than 10 years and who have been recruited in the sanctioned post. According to Mr. Basu,
So 10 years that I have considered.
yes, but this is his additional submission is that 10 years your lordship has considered. But the consideration of the cut-off date that the persons who have appointed after 10/4/2010 as per 2011 notification, that submission was not pointed out before lordship. That is his submission. He now goes back to that. He now will not accept that this 10 years has been considered. But this 10 years service, that is absolutely interlinked with that cut-off date. And as on 2011, that was the cut-off date, but subsequently it is relaxed. But be that as it may, that kindly comes to paragraph 11. It is further contended by Mr. Basu that on perusal of the subsequent notification, it would reveal that 2 subsequent notifications are mere addendum to the previous notification dated 16/9/2011 and those have been issued by the respondents considering the escalation of price. I have submitted that the cost of living and the financial need of the contractual delegated employees. But as a welfare state, the state has taken this policy. Very good. It is further argued by Mr. Basu that under no stage of immunization, it can be said that subsequent notifications have an superseding effect over the notification dated such and such. It is that argued Mr. Basu that since present petitioners' tenure work are less than the period mentioned in 2011 circular, they have not been recruited in a sanctioned post, they will not get the benefit. Then will not kindly come to paragraph 14. On perusal of the entire materials constitute the clauses of the 2011 circulars also. Your lordship need not discuss each and every clause in the judgment. On perusal of the entire materials as placed before this court, and after hearing the submissions of the learned advocate for the contending parties, it appears that it is undisputed that present petitioners have been appointed OBC Department of Contractual Employees and their emolument salary have been mentioned. Admittedly, present petitioners have been appointed in different posts in different categories. Prima facie, it appears court that they cannot stand in the common platform. That this is the single writ petition should be filed or not. That is not. So the common writ petition which they have done, however, they have to file requisite court fees. That I have done. Then paragraph 16. This is important. In order to come to a logical conclusion as to whether the benefits of the notification can be extended to the present writ petitioner.
Just a minute. Yes.
That in order to come to a logical conclusion as to whether the benefits of the notifications dated 25/2016 and 8/2019 can be extended to the present writ petitioners, this court proposes to look the first paragraph of the memorandum dated as published by the Finance Department of the Government of West Bengal. Then it is quoted. Then on perusal of the aforesaid relevant portions of the memorandum as issued by the state, it reveals to this court that the respondent state had an intention to provide security of tenure, appropriate emoluments, some terminal benefits to the casual contractual workers who have worked for a considerable length, more than 10 years. Admittedly, the petitioners before this court have not worked more than 10 years. At this juncture, if you look to the subsequent 2 notifications dated such and such, it reveals to this court that respondent state while issuing the such notification has again considered the eligibility of the entitlement of the appropriate emoluments, security of tenure, certain terminal benefits to the casual designated contractual workers who are working in the different department of the state, categorize the state employees in different tables on the period of without engagement, such as less than 5 years, 5 to 10 years, and so on. Thereafter, on comparative study of the aforesaid 3 notifications, as discussed supra, it thus appears that while issuing the subsequent 2 notification, state authority has also considered the case of the casual director who had worked less than 10 years. That is, those workers, employees have been categorized under 2 tables. In view of such categorization, in considered view of this code, the ceiling of 10 years, this is not entire, I was submitting, entire circular is not obliterated. Ceiling of 10 years as fixed by the state by its notification has given a go by.
It should be go by.
Yes, go by. So my contention, as if your lordship has observed that the entire notification of 2011 go by, that is not correct. Only the ceiling or restrictions or rewards of 10 years service, that has been go by. After in view of the discussion, this holds that notification has practically lost its significance in respect of those employees who have worked less than 10 years. The other conditions remain. So regards of 10 years continuous, that has been go by. That contention is not correct. That by these observations, your lordship has not considered proviso to clause 5. That's why this notification has been given go by. So that's why it's warrant review. So thereafter, my lord.
Anything more, Mr. Dhar? I
Yes,
think we
yes,
have concluded.
Just one thing, Lord. The citations and the technical point. I did not raise the technical first issue because my learned friend tried to pursue the lordships by his artistic submission of the merits on this. That's why I tried to pursue it. But I feel it's my duty to point out the technical point. Very short 2 points and the judgments also. Firstly, সেটাই তো বলছি তো মানে there was a dichotomy right from 2017 Calcutta judgment, and thereafter I found one Veravas judgment full bench considering the Calcutta. I just summarily say, if a review application is filed and subsequently appeal is filed, the one view was that till the appeal is disposed of or heard, the review should be kept pending. Review should not be heard. That issue was raised. And the Allahabad High Court, following the old judgments of Calcutta High Court, also Madras High Court, held so that if the appeal is filed subsequently, review need not wait. Review has its own scope, jurisdiction. Court passing the original decree must decide the review application if the appeal is not heard or appeal is simply filed or pending.
Order 47 clearly prescribes that if no appeal is filed.
Yes, I'm coming. Why here, in this case, and that judgment also, it was observed. It was firstly 114, thereafter order 47. Kindly comes to page 147. That's why at the outset I say that these submissions may not be made if my submission prevails with your lordships, that this review application itself is not pending.
Kindly comes to any person considers aggrieved by a degree or order from which an appeal is allowed by this court, but from which no appeal has been preferred.
Yes. So
your appeal has been preferred.
Yes, I'm coming. The first, my lord, section 114 has to be read in order 47. Section 114 allows the review in what circumstances, conditions enumerated in 47. So test conditions enumerated 47 are to be, my lord, satisfied if I come under the circumstances under 14. 114, subject as aforesaid, any person considering himself aggrieved by a decree or order from which an appeal is allowed by this court, but from which no appeal has been preferred. Here, in this case, my learned friend contention would be that I preferred the appeal long ago before filing the review. That appeal, on the advice of the then council, was filed. Subsequently, nearly 6-7 months, they withdraw the appeal. But they prayed for liberty to file review application. That liberty was not given.
Not given?
Not given. That is not mentioned, but the simply appeal was allowed to be withdrawn. without giving any liberty to file the mention করা আছে. So the appeal was kindly comes to page 120 of the paper. Even I thought for service of the copy of the memorandum of appeal stay application, they did not serve. Your Lordship kindly recall, kindly comes to page 120. The appeal was filed in 2024. Your Lordship's judgment is dated 8 February 2024. Mat 952 of 2024. The appeal that your Lordship will find 120. Has your Lordship got it? Page 120. The appeal was filed in 2024, immediately after judgment was passed. And thereafter, on 1st of March 2025, the appeal was withdrawn on their prayer, unconditional.
2nd January.
2nd January. And review was filed thereafter. So they prayed for condonation of delay. Your Lordship was pleased to allow the condonation of delay. Then your Lordship is this. My submission, his submission probably would be, this is the appeal, withdrawal appeal. There is no decision on merit. So I am legally entitled to. There also I have the authorities. But your Lordship knows I did not cite authorities on that.
No.
Dismissal of the appeal.
114.
Appeal, when appeal is provided, no appeal is filed. But here appeal is preferred and dismissed as withdrawn. Effect is that appeal is dismissed. Effect is that the appeal was filed and on there is
So for the
section
language,
114.
any person considering himself aggrieved by a decree or order from which an appeal is allowed by this court,
Where
but
appeal is,
but from which no appeal has been preferred.
but here appeal has been preferred. And more so appeal has been withdrawn. So the review is absolutely not maintainable.
Judgment,
Review is not at all maintainable in its present form. Because had it been a case, the review filed earlier,
what order 47(7) says?
order 47, that is mistake apparent in the face of the record and sufficient cause, they will deny. They say, but it is not subject to the satisfaction of 114. Order 47,
Of course.
order 47 cannot be read in isolation.
That is the prior one.
Absolutely, madam. I bow down. So my submission is that since in view of section 114(1) or A, this review is itself not maintainable. Your Lordship need not go into the other questions here. But since we have deliberated, your Lordship will consider.
No,
Now
if
let
you
me
read
tell-
Mr. Dhar,
My lord.
kindly come to order 41, order 47, rule 1, sub rule 2.
Yes. Yes. That any party who is not appealing from a decree or order, who is not appealing from a decree or order, may apply for review. I stop here. I did not make any further submissions. Their dependency to appeal some other party. This is another aspect also. Suppose not a party.
It starts with the party is
No,
not
this
appealing
is-
from a degree or order may apply for review.
No, this is another case. It is a case where a
No,
party,
notwithstanding the pendency of an appeal at the other instead of
other
the
parties. Yes, that's why this subscription is there. But my submission is that in view of section 114A,
So, order 41, I believe order 47, rule 1, sub rule 2, does it say again that a party who is not an appealing from a degree may apply for a review only?
no,
It's not so.
it is say, yes, parties who is not appealing from, he may apply.
He is on
That is not in my case. In my case, the appellant itself, they preferred appeal, withdrew appeal. They will only rely on clause 1, the face of the record, the after C, sufficient for any other sufficient clause, or there is ever error upon the face of the record, as per order 47. But that is subject to the condition of 14114A.
Any other point?
Yes, just two decisions on this. That once the appeal is disposed of, review is not maintained. Till the appeal is not disposed of, the review is maintained.
Even if the appeal is preferred.
Even if the appeal is preferred. But subsequent to the review. Subsequent to the review application is filed, thereafter appeal is filed. Then there is no embargo to hear the review application. Here the case is reversed, but in that context, court held that the under kindly comes to this. This is AIR Allahabad 1948, Allahabad 353. Allahabad 353 full bench. So following Calcutta High Court,
Respondent writ petitioner.
just come to the head note itself.
Review respondent. ঠিক আছে।
Let's kindly come to the head note B itself.
B for Bengal or D for
Yes, B for Bengal, small b, the first page.
Yes.
Civil Procedure Code 47, Rule 1, power to entertain review remains in existence till appeal from decree is not heard and disposed of. Paragraph 41, it is there. The Madras High Court took a decision and the issue was referred to the full bench that whether when the appeal is subsequently filed after the review, whether the review should be heard. In that context, the court held so, and paragraph 41 also. Paragraph 41, it is there. Following Calcutta judgment, 41 CWA. Yes.
51 টা কোথায় গো?
That paragraph 41 at page 362, right hand side, this old book, that's why that the power to entertain is 15-20 lines from the top. The power to entertain the review remains in existence.
Page number?
Page 362. The paragraph 41 starts, kindly comes to the right hand side passage.
Oh, right hand side.
The crucial date. Crucial date. Crucial, there is a pointing mark. Photocopy has come. Crucial date. Crucial date, therefore, is the filing of the application for review. If on the date the appellate court has no appeal pending before it, the review application is under court as it stands competent. Power to enter into the review remains in existence till such period as the appeal is not heard and disposed of.
So, Dhar, I am not getting.
My lord.
Paragraph 41 you said, no?
Yes, paragraph 41. Paragraph 41, page 362, right side, may I just mark in my page?
No, please mark in my page.
My lord.
Paragraph 41.
I hand up to your lordship.
39, 40, 41 to
My lord has got it.
I believe one page is missing, sir.
Page 362. My lord, can take this now.
Eta dekho to, you just check whether one page is missing or not.
Can you take this?
देखिए एक बार
might be, but kindly pardon me. Page 362 has it.
Give me a second. 49 sub holder. 49 sub holder. No, page is missing.
But this the one I am handed up. Might be there.
362 paragraph.
Yes,
page paragraph number 42.
42. 42, right side, mother.
Bottom.
Yes, right side, no, bottom, no, top. The sentence starts from crucial date. Crucial date. Justice Sapru, mother.
The crucial date, yes.
Crucial date, yes, ma'am. The crucial date, therefore, is the filing of the application for review. If on the date the appellate court has no appeal pending before it, the review application is under the court as it stands competent. The power to entertain the review remains in existence till such period as the appeal is not heard and disposed of. This is a full bench decision relying on Calcutta judgment. And so this is the submissions, and similar, there my learned friend will say that because of the dismissal was not on merit, because of simply withdrawal, so there is no merger. They will say that, probably. That there in the similar circumstances where the appeal was withdrawn, review was not filed. Madhya Pradesh High Court unreported judgment. I have taken from the website. Kindly take this. Darshokকে দিলে একটু দেন। The challenge in the present appeal is to an order. Here the situation is that appeal was withdrawn. Thereafter review application was filed. Review was withdrawn. Thereafter again against the order appeal was filed. So in that context, firstly, the challenge in the present appeal is to an order passed by the single bench whereby the writ petition filed by the petition was dismissed. Appellant filed a writ appeal, and the learned counsel appellant wishes to withdraw the present appeal. Writ appeal is dismissed as withdrawn. Similar order. Then, it thereafter filed the review petition. The order is that seeking review of the order passed in a batch of petitions, this review petition is preferred. It is relevant to point out that petitioner has preferred a writ appeal against the order dated such and such, which has been withdrawn by the appellant without any liberty to apply for review. In such circumstances, in my considered opinion, no case for review is made out. Accordingly, review petition stands dismissed. Thereafter, appellant has filed present appeal against the order dated 23/3/2017, the original order. When the appeal came up for hearing on such and such, counsel for the appellant sought to time to address the arguments on the question whether appeal would be maintainable after having withdrawn the earlier appeal. So that is the context. Now the merger point, my lord, kindly comes to paragraph 7, next page, page 2. So many decisions have been cited. I just do not trouble. Your worship will see paragraph 7. The appellant has withdrawn the writ appeal unconditionally against the order dated such and such. Withdrawal of the writ appeal unconditionally will lead to relinquishment of the claim of the appeal, appellant in appeal. In other words, it means the acceptance of the findings recorded by the learned single bench. Therefore, once the appellant has accepted the finding of the learned single bench while withdrawing the appeal, he cannot be permitted to challenge the same impugned order once again. So that is the authorities. Now coming on to the review. This is very important. I try to be very brief. I rely on firstly the judgment of very recent judgment of the Honorable Supreme Court, where one of the parties was Honorable Justice Dipankar Datta. It's reported in SCC Online. Shishanu. This is reported in 2024 SCC Online, Supreme Court 1764. 2024 SCC Online, Supreme Court 1764. Paragraph 10 to 27. These are the discussions on the review. I did not read the entire paragraph. The sum and substance is that if by reason of elucidation, discussions is required, where there is possible two views and where there is no error apparent on the face of the record, where the point urged in the review petition is to be decided on by logical reasoning, detailed reasoning, then review is not permissible. Kindly comes to paragraph 11, internal page 14 first. There are so many decisions have been cited. While proceeding to determine the correctness of the impugned order, has the lordship got it? The vis-a-vis the exercise of review jurisdiction, we ought to remind ourselves of certain cardinal principles. The exercise of review jurisdiction is not an inherent power given to the court. The power to review has to be specifically conferred by law. In civil proceedings, review jurisdiction is governed by section 14 read in conjunction with order 47 CPC. The court has to be certain that elements prescribed therein are satisfied before exercising power. The Kamalesh in such and such has succinctly observed, review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of order 47 rule 1. The provisions contained in section 114 and 147 relating to review of an order or decree are mandatory in nature, and petition for review not satisfying the rigors therein cannot be entertained ex debitio justitia by a court of law is tried. There is plethora of decisions, but I skip over this. Paragraph 14, my lord. The order 47, my lord, rule 1 is quoted. I did not, my lord, travel. Lordship kindly comes to paragraph 15. In Mohan such and such, this court approved the view that the third ground, any other sufficient cause, must mean a reason sufficient on grounds at least analogous to the first two grounds. The same view has been reiterated in recent decision. This court affirmed that the scope of third ground had to be narrowly construed so as to not to traverse beyond the orbit of the first two grounds. Sufficient clause is not wide expression.
I believe they are on clause B.
Yes.
Mistake or error apparent on the face of the
Now,
record.
yes.
In consideration of the proviso.
Provides.
That
But-
may be.
Yes.
So Mr. Bandyopadhyay has not exactly quoted that, but that is the
Now-
crux, I believe.
Now, to
Am I
buttress
correct,
that,
sir?
yes, yes. But kindly comes to just paragraph 21. It is Mr. Bandyopadhyay's main contention that the relevant other clauses of the Circular of 2011 has not been pointed out or considered. But I press the judgment that your lordship consider the judgment, and this paragraph says
No, what do you say? Will you repeat?
that the my understanding contention that the relevant clauses of the Circular 2011, more particularly clause 5 proviso, that has not been pointed out and not considered by your lordship. But your lordship has considered the entire circular, not the yes. And now, if one aspect of the circular or one aspect of the case has not been canvassed at the time of final hearing, and another counsel will be coming and canvassing the points which have been left over, that can be ground for review. That is in paragraph 21. In Mira Bhaja such and such, this court affirmed the ratio in Anirban such and further expounded that review proceedings were not by an appeal and would have to be strictly confined to the scope and ambit of Order 47, Rule 1 of the CPC. It was further held that an error apparent on the face of the record must be such an error which must strike one on mere looking of the record. My underframe contention cannot be decided just merely on the looking of the record. It needs reasoning, detailed reasoning, obviating the need for long drawn reasoning on two possible opinions. This court in such and such drew our attention the contours within which review jurisdiction of this court had to be exercised and held that the Order 47 CPC does not allow.
Last three line is very important.
Yes, that's why that I'm saying that. Does not allow for re-hearing of a dispute merely because the party has not highlighted all aspects of the case. This is not the latest judgment of the Supreme Court. Not other judgments, where I just say the paragraphs, I did not travel your lordship.
Don't request. I believe you have argued all the points. Very
Much. I'm deeply obsessed.
Lord, as far as the appeal withdrawal, maintainability of the review which is being taken at the hearing stage, my lord, I would have appreciated that the point was taken at the earlier stage.
That is taken. My lord friend said that it was maintainability kept open. That's why my lord said that finally I
Lord,
will
two judgments has been shown, one of Allahabad and one of
how do you overcome
Madhya
that one?
Pradesh. That's settled by the Honorable Supreme Court, my lord. Even if I go up in Supreme Court, the SLP is dismissed.
SLP is separate.
My lord, there is no merger. My lord, when the appeal is there, my lord, the appeal I have withdrawn. There cannot be any merger with your lordship's order. But kindly see the principle, my lord. The principle is settled.
SLP and appeal is separate.
My lord, 2011, 8 SCC 679.
But I must be candid that this submission, that the dismissal of the SLP without granting the SLP, whether barred to proceed with the review application, that was considered by the Supreme Court. And the issue is referred to the larger bench, which is pending. But my case, SLP is different than appeal.
Well, kindly
SLP becomes an appeal when it is admitted.
Let me
Yes.
hear Mr. Bandyopadhyay.
when it is admitted, my appeal was never admitted. My appeal was withdrawn at the threshold. maybe after some time.
Reference to Polo.
2011, volume 8, SCC 679. 2011 8 679.
Yes, sir.
33 to 38. 33 to 38.
Para.
Yes, para 33 to 38. 34 is mostly quotation of another Pune Med, Pune Med for the state of Kerala. And it takes on 35.
Yes.
In view of the principle laid down above by this court, even after the dismissal of SLP, the aggrieved parties are entitled to move the court concerned by way of review. In the case on hand, though the appellant moved the SLP in this court against the order of the High Court in the second appeal, admittedly the SLP was dismissed as withdrawn without the leave of the court. A similar question was considered by this court in Sarguja Transport versus Stat. In this decision, it was held that where a petitioner withdraws a petition filed by him in the High Court under Article 226 without permission to institute a fresh petition, remedy under Article 226 should be deemed to have been abandoned by the petitioner in respect of the cause of action relied on in the writ petition, and it would not be open to him to file a fresh petition in the High Court under the same article, though other remedies like suit and writ petition before this court under 32 would remain open to him. It was further held in Sarguja Transport that the principle underlying order Rule 1 of Order 23 CPC should be extended in the interest of administration of justice to cases of withdrawal of writ petition also. The main contention urged by the learned counsel for the petitioner in that case was that the High Court was in error of rejecting the writ petition on the ground that the petitioner had withdrawn the earlier writ petition in which he had questioned the order passed by the tribunal on so and so without the permission of the High Court to file afresh. It was urged by the learned counsel that since the High Court had not decided the earlier petition on merits but had only permitted the petitioner to withdraw the petition, the withdrawal of the earlier petition could not have been treated as a bar to the subsequent writ petition. While considering the said question, this court considered Rule 3 of Rule 1 of Order 23 and its applicability to the writ petition filed under 226 and 227 as held under. Then the quotation kindly skips over. Then 38. In the light of the discussions in the earlier paragraph, even after dismissal of an SLP, with or without reason, the aggrieved party is entitled to file a review. In view of the language used in Order 47, Rule 1, Sub-Rule 1A, that is what fell from your Lordship, the same language. Your Lordship, it fell from your Lordship to Mr. Dhar. Same language is being interpreted. CPC, which relates to review the present review petition, cannot be dismissed on the ground of maintainability. Based on the above discussion and reasons, we hold that the review petition filed by the appellant was maintainable, but in view of Order 3 of Rule 1 and 4 chapter relating to the rules of pleaders and view of the conduct of the appellant in not raising any objection as to the act of their counsel except filing review petition, we are not inclined to accept the claim. So rejected on a different ground, on merit, rejected on merit, but it says that even after it is withdrawn, appeal is withdrawn, the review will be maintainable in view of the language of Order 47, Rule 1, Sub-Rule 1A, which fell, the language which fell from your Lordship. My learned friend's submission was that 114 will not be overridden. Here I have not pursued the appeal. So there is no appeal on board at all. And as far as the other judgment is shown, Malad, it does not say that the reviews for the coming times will be beyond 114 and 47, Order 47. If my ingredients of Order 47 is available to me, which is either apparent on the face of the record, then the review will be maintainable and your Lordship will entertain the review. And my learned friend was there. He has, I don't know if he has any problem in me appearing. He's repeatedly said that the council changed, council said re-argued. My learned friend, my learned friend was there in contact.
I appreciate it.
I know Mr. Bandyopadhyay.
I also
know Mr. Dhar. For the
No,
politics
no,
personal.
No, I am not taking it personally. Kindly hear me out before. Don't console me without hearing me.
No, no, please.
What I am trying to say is that Mr. Dhar was there from the beginning of the matter. Mr. Dhar knows that Mr. Jawaharlal Dev was appearing in the matter throughout. Then he stopped appearing, and then Mr. Rajesh Basu appeared on the last day on the matter. But I can show all this, but there is no point in going into all this. But I am absolutely on the merit of it. But my last submission on reply is that, my learned friend has not even touched upon his engagement order. You'll also remember, I showed page 33, 36, 39, his engagement order, which refers to his engagement memo and the remuneration fixed there. My only submission, your lordship will kindly take his engagement order, that is page 33, and turns over to page 34.
I have dealt with that.
This entire submission that he has made, I'll just show, how this mother memo of 16 September 2011 is not applicable to him from only one document. Kindly take.
I submit. I
kindly
take to this point, but I submit that.
I am on reply. Kindly allow me to give reply also.
Next again, you can say that.
Yes, Mr. Bharat.
Page 34, your lordship has seen. The petitioner number 1 is having a remuneration of 12,000. Your lordship will notice. This is in 2018, when the modification of 25th February 2016 is already existent. But the modification of February 2019 is not existent. Therefore, if 16 September 2011 is applicable to him, he is someone who is below 5 years. That is his argument. That goalpost has changed. That criteria is not there anymore. And he is fully covered by 16 September 2011. Then his remuneration should match to all the remuneration mentioned in 16 September 2011.
That is his grievance. It is not matching.
There is the engagement order. This is his engagement order. But a person is engaged. On a particular day, he is engaged.
That you have argued, sir. I can remember your argument is that since this person have been engaged with a particular memo, their terms and conditions of payment will be covered under this memo.
Right. Today, the document he is showing today,
No, that will not be taken care of.
Yes.
Only that document will be taken care of, which has been annexed to the risk petition. That
Right.
be rest assured.
No, part of the writ petition. He said we have
it
this
is
one
part of-
document.
No, that which is the
57.
document which has been made part of the writ petition.
It's 14
that-
February 2019.
57 page.
That
57.
will be taken care of. I
Yes.
will return this. এটা ফেরত দিয়ে দাও।
14 February 2019.
No, I will not allow Mr. Dhar to take.
I'm not on that. Or not on that document, the other document. 14 February 2019 document.
Page 57 of the writ petition, which is not
14
part of.
February, your lordship has 14 February, also given separately. Kindly see the top of it.
Yes.
Refers to 16 September 2011.
Yes. And also 8 February 2019.
While revising the order,
Yes.
revising the pay scale.
Yes, but not in this case, not for the petitioners.
That's
Petitioners are not engaged under that memo.
I understand, sir.
But,
Take down. No more.
I am
Create an
not
argument-
saying that it is
arguing the
about,
cases.
I never take anything personal. It is always for my clients.
That is the nicety of the legal process.